Hello, my name is James Turner and I am Senior Solicitor at Laurent Law, Barristers and Solicitors, located in Grey Lynn, Auckland, New Zealand. We are a law firm which specialises in New Zealand immigration law. Now, I have previously delivered a video blog about partnership visa applications, but in this video I would like to talk about partner visa applications some more, but with a different angle on them, and also give a few more examples in the form of case studies. So this is Partnership Visas 2024. The key requirement for the approval of a partnership visa in all cases is that the applicant meets the test of living together in a genuine and stable partnership. The onus is on the applicant to demonstrate to an immigration officer that the living together in a genuine and stable partnership requirement is met. In carrying out this assessment, Immigration New Zealand will consider documents submitted by the couple and in some limited cases may carry out an interview. Case Study 1. This case study demonstrates the importance of at least 12 months living together for a partnership residence application to be approved. I talked briefly about this one in my earlier partnership video blog. INZ can be quite sticky about the 12 months living together requirement. We have seen cases where Immigration New Zealand has counted the days the couple have been living together to ensure that at least 12 months living together has been met. We took over and handled a residence application for a couple where one of the partners was living at a different address for some nights of the week. The question Immigration New Zealand raised was whether the couple had been living together for at least 12 months prior to the application being filed, as is required by instructions. We responded by saying that the reason for living at the alternative address, which was at the opposite end of Auckland, think the extremes of north and south, was to avoid long distance travel to and from work in rush hour traffic, which indeed can be very problematic. We explained with reference to tribunal decisions that periods of separation in a partnership are acceptable. Alternatively, we explained with reference to tribunal decisions that spending some nights of the week elsewhere does not preclude a finding of living together where there is evidence that there is a shared residence. On this approach, the couple could be viewed as living together continuously for longer than 12 months, and periods of separation were not a relevant factor. This residence application which I am talking about was approved. Case Study 2. Section 61 request followed by successful partnership applications and with a character waiver. In this case, our client had been an overstay for about 6 years after arriving in New Zealand on a student visa. The client had entered into a relationship with a New Zealand citizen and they had a son together. Our request for a visa to the Section 61 team at Immigration New Zealand was declined, so we had to go to the Associate Minister of Immigration. A delegated decision maker granted our client a 6-month visitor visa. From there, we filed a partner work visa and a partner residence application, both which were approved. What made this case particularly difficult was that there was an allegation that our client had provided false and misleading information with her student visa application, when in fact it appeared she had been scammed by an unlicensed visa agent in her home country. This allegation of false and misleading information required the grant of a character waiver, which we were successful in getting approved. It was reasonable for us to place emphasis on the fact that the couple had a young son together who was a New Zealand citizen. There are decisions of higher courts in New Zealand, including the Court of Appeal, which state that the best interests of children under the United Nations Convention on Rights of the Child have to be considered in decisions made by government officials such as immigration officers. However, I do want to emphasise that not every situation involving overstaying can be fixed. A lot of hard work, attention and perseverance from both us and the client is required to achieve success. Unless there is something compelling about the relationship and the situation generally, we would normally say that the chances of getting a client from unlawful status through to residence based on partnership does have a limited chance of success. Case Study 3. Permanent residence application for a couple living together overseas for longer than 5 years. If someone has been living together with a New Zealand citizen for at least 5 years outside New Zealand, they can apply directly for a permanent residence visa. The travel conditions on a permanent residence visa allow travel to and from New Zealand indefinitely, whereas a standard residence visa will usually allow travel to New Zealand for 2 years, after which time further travel conditions or permanent residence must be applied for separately. Therefore, it can be advantageous to be able to apply directly for permanent residence. This type of application for permanent residence is good for Kiwi expats who have spent long periods of time living overseas, maybe due to work commitments, for example, and have found themselves with a partner who is a citizen of another country. However, what can be a challenge with this type of application is preparing the full evidence of 5 years living together. Quite a bit of paperwork is required. Our law firm has assisted with several of these types of applications in the past few years with success and happy clients. Thank you for listening to my updated video regarding partnership visas. It's Partnership Visas 2024, and I wish you all the best.